Now, the High Court in Pretoria has set aside parts of the 2018 VBS Bank Heist report. That report, compiled by Advocate Terry Motau at the request of the SA Reserve Bank, unpicked a web of payments and corruption that ultimately destroyed the bank and left thousands of people without their life savings. Msiza is one of the people mentioned in that report. The ANC treasurer in Limpopo was accused of using his influence to convince ANC municipalities in the province to illegally place their money with the mutual bank. But today, the court in Pretoria ruled that parts of the report were flawed procedurally and his name should be removed. To tell us more about this, I'm joined by the lawyer for Msiza, Joseph Maluleke. Good evening, Mr. Maluleke. Thanks very much for your time. We appreciate it. You know, your client was suspended by the ANC for 2 years and then recently reinstated. He's yet to be charged in the VBS Bank case. Now, parts of the report implicating him as a kingpin have been set aside. Is this vindication for him today?
Good evening, and also to your viewers. Of course, it is a vindication to his constitutional rights, because what transpired in this matter was very unfortunate. Msiza was basically put out or able to hang and dry in the court of public opinion based on baseless allegations and basically conversations that people had where his name was mentioned. And we had expected that when Advocate Motau basically interviewed people on this matter, and it became clear to him in the course of his investigation that our client, Mr. Msiza, was implicated in some way or another, that he would, in terms of the might of the law in terms of which he was appointed to conduct the investigation, to call our client and to put those issues to him in a manner that allows him, as the constitution of the country demands, so that any adverse findings or conclusions that would emanate from such investigation pertaining to our client would be happening, at least having regard to his right to procedural fairness.
So this is the, and correct me if I'm wrong, the Audi Ultram Partem rule, which basically means you have a right to reply. Is it that he was not approached at all by Advocate Terry Motau, or that he was only approached after the report was published?
No, we were all surprised that Terry Motau never at any stage whatsoever invited Mr. Msiza to come and explain himself insofar as allegations were made about him in the course of his investigation. And what was even more surprising was, as I said, the Financial Sector Regulatory Act had given Terry Motau the powers to call people and, if necessary, to subpoena them to appear before an inquiry. So much so that if you were subpoenaed and you did not come, he could have a warrant for your arrest issued to the authorities in order to secure your attendance. And that is very, very profound. And he never applied those tools that were before him. Instead, you will recall there was a very interesting interview which took place with Stephen Grootes in one of the radio stations, where Stephen put a direct question to Motau and said, but why have you not called Msiza to come and explain himself when you saw that people were mentioning his name and implicating him in some or other allegations? And his response was that he, and I'm going to try and quote him verbatim, and he said, you see, when people begin to protest their innocence before they even know what you have against them or what information you have pertaining to them, I realized as Terry Motau that I stand to benefit nothing by calling Msiza to the inquiry in order to face certain questions. And that it's very sad, because it just showed the level of bias that obviously is it's regrettable from a legal person of Advocate Motau standing as a senior counsel, because that undermines the basic tenet of our constitutional law and the common law, which is the odi alteram partem rule, that requires that if people are accused, you need to bring them and tell them what it is that they are accused of and allow them the opportunity to explain themselves. And when you do that, the Constitutional Court has frowned upon such conduct, because effectively what Motau has done was he got Msiza thrown into prison. And after he went into prison, which is what he tried to do during the court proceedings through the Reserve Bank, because, by the way, as we speak, Terry Motau has never challenged all the allegations that we made in the court papers on behalf of our client against his report. He has never challenged those, despite his protestations on all media platforms saying that he will come to court and defend his report.
Well, this is
largely our court challenge and the response coming from the Reserve Bank was based largely on hearsay.
I mean, I was going to ask you if this is a case of justice delayed is justice denied. I want to go through, there's a couple of paragraphs that have now got to be taken out of that report, featuring Danny Msiza's name, alleging he was a kingpin, that he used his influence to get mayors to deposit money, references to WhatsApps with Bra Danny mentioned, that he introduced people to each other. All of that has now got to go. Because of that, in your view, is your client now no longer vulnerable to any possible prosecution in this regard, or do you still have some concerns?
We've never had any concerns because, remember, Danny is not facing any investigation by any of our law enforcement authorities as a suspect for having done anything. Even the decision by the ANC's Integrity Commission was largely based on the media reports making reference to the Terry Motau investigation report. So our view is that if there is some other evidence that any of the law enforcement authorities have against him, as we speak today, we are not aware of those, and obviously then we can't comment about that. We'll cross that bridge as and when we get there.
I was actually going to ask you about the decision recently by the ANC after your client and Florence Radzilana were suspended for 2 years. They were recently reinstated by the ANC, which is sort of overruling what the Integrity Commission originally decided. Can you comment on why the ANC did that before this ruling? Were they aware that it was coming?
We have, on behalf of our client, at some point, wrote a letter to the NEC of the ANC, and the top six in particular, to say to them that the reliance on the media reports by the Integrity Commission to request our client to step aside from his position had no legal basis to start with. And because even in the constitution of the ANC, this step-aside thing we're hearing about in the media does not exist. In the ANC, if you have done wrong, you get called, to a disciplinary inquiry. Charges are put to you. You have an opportunity to have your say, and a decision is made whether to suspend you or to expel you from the organization. So in terms of their own constitution, this so-called step-aside business it's a foreign concept that is not there, and it's just a question of Msiza being disciplined and not wanting to pursue his party through media and so on, that he subjected himself to say, you know what, I will step aside. But as I say, that step aside from the Integrity Commission really had no legal basis whatsoever. And we wrote to the top six of the ANC to say, you need to allow Msiza to go back to his office, because if you don't, and you are wanting to place reliance on the Terry Motau report. At that point, we had already received an answering affidavit from Mr. Kuben Naidu of the Prudential Authority of the Reserve Bank, where he simply said, but we have not made any findings against Msiza. Then, it was now, because we had already put arguments in court We couldn't do anything about it. We had to sit and wait for the court to come and make a ruling because
Mr. Maluleke,
there was really no case.
Mr. Maluleke, I'd like a general comment from you. Obviously, what's happened today has, as you say, vindicated your client. Do you think it casts questions over the entire report, or do you in the main feel that your client was pulled in unfairly and this report still stands and there was some serious wrongdoing at VBS?
I think we obviously do not speak for the other people who are implicated in the VBS report, and certainly we do not, want to rubbish the report in its entirety. And those people who have been implicated in the report, just like our client, had an opportunity when the report came out to take the author of the report to task in terms of vindicating their own rights, and they have elected not to do so. So I will not venture into talking on the report as a whole, but our point is simply that our client was unfairly pulled into the report, and there is simply no legal or factual basis why Advocate Motau had, proceeded in the manner that he did to infringe our client's rights to human dignity, to freedom of trade. And this has costed him. He was labeled a kingpin when there's not even a shred of any evidence whatsoever at the commission to deal with him. And what we saw was attempts in the media to try ex post facto to justify what Advocate Motau ought to have done and he didn't do. And I mean, we can't comment on media reports and stuff like that. As lawyers, we work with facts and evidence. And we went to court and we said to the judge, and this is simply not done in a constitutional democracy. People have rights, and the Constitutional Court had made quite strong, rulings against commissions of inquiries where people are called to commissions, or at least statements or information is laid out in the commissions without people having their right to audit.
You make an important point, and thank you so much for your time today, Joseph Maluleke. He, of course, is the lawyer for Danny Msiza.